Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Put your questions in the comments now. Today, I want to spend most of today focusing on your questions. I do have a great update for you. So I brought this up, I believe, on Monday that the Immigration Service will now be issuing 5-year um, 5-year work permits in the coming fiscal year, which will be after October 1st. Well, they made the official announcement that they are extending work permits from 2 years to 5 years. So that means, and the reason they're doing this is because some processes are taking that long, unfortunately. And it's really stressful. I know because I represent clients who have to renew their work permits. I do represent clients throughout their entire process, which means that my clients are, I represent my clients for anywhere from 2 years to up to the 5 years or more, whatever it takes to get our clients a success. And when we get our clients the work permit, one of the things that we have to keep doing is we have to keep renewing those work permits every 2 years. At one point, it was every year. Now it's every 2 years. And you would be so surprised how quickly 2 years come up. And we are constantly having to submit renewals for the work permits. So now to reduce the stress that immigrants have to face, because remember, when they don't have their work permit, they can't have to stop working. Lawyer, well, how can you show work permit? So it really disrupts the lives of my clients when they're unable to timely get the renewed green card. So one of the things they did, they temporarily extended the work permits for 540 days after expiration, as long as they timely apply to renew it. Now, that helped a little, but you still want to have that card, and so does the employer. The employer, I've had to sometimes advise my client to make sure they show the receipt notice to show the automatic extension, because you have some employers that, even though they're supposed to, they give my clients a problem to accept it, and we have to be back and forth on it. So, to reduce all of the stress on the immigrant side, and also to reduce the backlog at the USCIS, they have decided to extend it for the length of time that most processes are taking, which is about 5 years for some. Not all, but 5 years is a safe time where everybody can have their work permits. And if their time goes longer than the expected processing time, they don't have to renew it. They can just keep working on that work permit. Because, my experience is once you have the work permit and you have the social security number, it tends to help my clients to settle into life, to get started on life, and really to make some headway while they wait for their permanent residence or wait for the status that they're applying for. So this is welcome news, and it is really necessary. I'm glad this is going to happen. Now, for example, my clients that are doing when we renewals, they're going to get the 5-year work permit. Now, this is for most work permits. Now, remember, work permits are tied to certain immigration benefits. So if you're going through adjustment of status, if you're going through so adjustment of status, remember that covers VAWA, that covers family based, that covers T status. So adjustment status process covers a number of different processes that my client is going through, and so they all will get that year work permit. Then, in addition to that, you have other types of statuses. So if you're applying for asylum, they're now going to be issuing the 5-year. If you've been approved as an asylee, you're getting the 5-year. If you have been paroled into the country, you're getting the 5-year. And even in some cases, so they have a list of countries that if you are coming into the country from there and you've been issued an I-94, you get to show just the I-94 as proof of your status, and then also for work authorization. So they don't even need to apply. But keep in mind, those are some countries, for example, like Afghanistan, they are covered under this if they're paroled into the country. So yes, this is great news, and it will really, it is welcome news because it will bring a lot of relief to my clients, because that is a major stressor for them. Now let me focus on your questions, because that is what I promised I would. And so let's go ahead and ask your questions now. Put it in the comments. I'm going to focus on those right now. Keep in mind that the information I'm providing is not personalized legal advice. It's general information. The way you're going to know whether this specifically applies to you is if you schedule an appointment and get personalized legal advice. All right, so let's go. Hi, madam. Good morning. Good morning. I got my work permit and travel document in my VAWA case. Can I apply for divorce now and my green card? How long will it take my spouse to create any problem against me or what? So that is very personal, and I wouldn't be able to advise you on those kinds of major life changes unless you are my client. Generally, this doesn't apply to you because I don't know what your circumstances are. But generally, the purpose of the VAWA is to protect you so that you can move forward without the spouse, even if you file for divorce. Now, if you never file for VAWA first, you file for divorce, if your divorce was finalized, you'd have 2 years to apply for this VAWA. If you applied for VAWA, then now it's in process, you want to move ahead with the divorce, yes, you can usually move forward with the divorce. Now, can cause problems for you? No, it's always best before the spouse even creates problems for you to make sure that you submit that VAWA, because that VAWA is going to be your protection. But a spouse can always call immigration. They can always claim certain, for example, claim that you've committed fraud, or, let the immigration know you're without status here. However, the rule is that they cannot use that information against you unless the evidence can be corroborated. So, for example, if the abusive spouse calls immigration and said that, he committed fraud, he convinced me to marry him, and it wasn't real. He or she didn't enter the marriage in good faith. Well, they're going to have to back this up before to do anything, including deny the application. Now, if they called, what I though is if when they call immigration before you filed your application and tell them that, then that is where you are vulnerable, because now they have that information and then you're applying for VAWA. They may very well count that against you because that allegation was made before you applied for the VAWA. So it can create some complications. So make sure, that's why I always say apply early, don't wait. All right, scrolling through. Does this apply to 245I? Yes, it does. Absolutely. It applies to adjustment of status under 245, which covers 245I. And that's the provision of the law that I'm referring to. Because remember, you can apply for adjustment of status under Section 245 of the INA, which is the Immigration Nationality Act. So it's the law that I'm referring to. How long will it take for your I-130 to be approved when you're married to a U.S. resident? So I'd say right now, you're looking at around a year, 9 months to a year. Hi, good afternoon. Is the USCIS experiencing a backlog? Oh, yeah. Well, story of my life and story of many immigrations' lives, and maybe yours too. Yes, I mean, it depends on what kind of case you're looking at, but all across the board, everything is usually taking longer than what it used to be before. So we can say that for sure, but what's your issue, and then what's your particular case look like? Then maybe I can give you more of an idea of whether that's normal. For example, with my marriage-based adjustment of status, going very well and going relatively quickly. However, with other case types, the processing times are going to be longer, but it depends on what's going on. What if you overstay your visa? Can you get a work permit? Now, I do have clients who have overstayed their visa, but they qualify for a relief or benefit to be able to get the work permit. Overstaying your visa alone is not going to cut it. You have to qualify. And this is what I do in the consultations is I evaluate, despite you overstaying, do you qualify for some type of relief or benefit that could get you to the work permit? Outside the country for 17 months and expired green card, what to do, you need to give us a call and we can advise further, but we need to understand what the situation is. When it comes down to staying outside of the country with an expired green card, for 17 months straight, there are issues that may be raised regarding whether you've abandoned your permanent residence. And so it's now a question of are you able to come back? If you come back, are you going to face an issue, or should you apply for what's called the re-entry permit for returning residents through the SB1 visa? Hello, I sent my adjustment of status after I got my prima facie, and I received a letter for extension for my work permit. Extended. I have to wait for. I'm not sure. I'm not sure what. It's not very clear to me what you're asking here. Um, So you received a letter. So it sounds like you applied for an extension of your work permit and you received the automatic extension letter. You don't, if you have the extension that shows that your work permit has an extension of 540 days, or it should be around that ballpark, then you can use that letter to continue to work, and then wait for your new work permit to come, and then update the employer. I hope that's what you're saying. I have a category C5, and it is taking forever. So work permits, it depends on what type, but yes, they are taking a while. Does it apply to deferred labor personnel who are applying for this kind of relief? So it does not mention deferred action. The reason being, with the deferred action, you get it for around 2 years. So they don't mention this here because they only talk about being paroled. They only talk about deferred action, being paroled, adjustment of status, withholding of removal, asylum, being paroled as a refugee, but they don't talk about deferred action, just because they tend to monitor that more closely and they give you in smaller increments, which is around 2 years. Hello, I have a question regarding my brother. He's over 21 and he's overseas. I'd like to apply for his green card. It's a 14-year process to apply for your sibling at a minimum. If you're in, for example, Mexico, it's over 2 decades. So you can definitely, a US citizen, you yourself are over 21, you can definitely do that. But just know that this is not going to be a fast and quick journey to the green card. So yes, this is great news. It really is. What about the VAWA application? So if you're applying for VAWA, you've applied for VAWA and you're applying for adjustment of status, then it is that 5-year work permit is going to apply to you. I received my SSN and an error is on it. Can I use it while they make a correction? So you probably can use a number, because if it's a name, they're going to issue you the same number with the corrected name. So yes. If a family petition is filed, can I apply for the work permit? Not just the petition. What you have to focus on, the work permit is linked to adjustment of status application, not the petition. So the petition is what your family member files to show that you qualified for the green card through them. When you're here in the US, you also file an adjustment of status application, and that's what allows you to get the work permit. I have a tax ID. Can I have work permit? The tax ID, which is also called the ITIN number, or if you have an employer ID number. So if you started up your own business and you've gotten EIN number, so none of those numbers can just get you the green card. I mean the work permit just like that, or a green card. What if you overstay your B1, B2? Can I still get a work permit? So I did answer this before, and this is where the consultation is very important. There are no shortcuts to get to the work permit. Just if you come here and you end up overstaying, that is not what gets you the work permit, right? So remember, overstaying is violating your immigration status. So that does not qualify you for the work permit. However, despite overstaying, my clients who have overstayed who qualify. That's the difference. Is my clients have talked to me. We've talked to them in detail. I've evaluated their circumstances, and I found in some cases that they qualify for a benefit that can get them to the work permit. But you should never be thinking this way. Never think, I'll just come to America, I'll overstay, and then I'll get the work permit. That's not how it works. And if you don't qualify for a benefit or relief, you're going to be stuck here without status. So getting overstaying does not equal work permit. What gets you to a work permit is if you qualify through family, through employment, through humanitarian means. Like, for example, with my clients, when they overstay, I ask them, what have they been through? Usually, after they've overstayed, they have been through a lot, and some of that involves trafficking. Sometimes they've overstayed because a family member convinced them to overstay and then didn't file their papers because they started to mistreat them. Could equal VAWA. If sometimes they've been the victim of a crime, sometimes they're here and they're afraid to return to their country because they are being targeted because of who they are, their identity, their beliefs, their political beliefs or affiliations. And so we're able to apply for asylum. So, that is what gets people to the work permit and relief. It's the relief that gets them the work permit, not the act of overstaying. What's the difference between asylum and withholding of removal? So withholding of removal, usually if you don't qualify for asylum, you can apply for withholding of removal in the alternative. That usually means that if you can show that you'll definitely be harmed if you return to your country, sometimes judges still order deportation, but put a hold on the deportation to say, since you'll face this condition in your country, you'll get withholding of removal instead. So it's not an official status. It just means for as long as that condition exists in your country that poses a danger to you, you will be able to stay here. And so if you have been granted withholding of removal instead of asylum, you can still get that work permit. Okay, so you have a pending I-485 application. Your spouse has committed a crime and is now in prison. What are the options? So in this case, you definitely consult with me, because first of all, what criminal act has she committed? Did it involve a minor? Did it involve you? And in that case, are you going to finish the process successfully? And then the other question is, are you going to make it? Is she going to make it to the interview? And how you can accommodate the interview if she's not able to attend. So give me a call, schedule an appointment, and we can ask these questions, answer these questions, and then we'll come up with a solution. Is an asylum a pathway to citizenship? Yes, it is to the green card and citizenship. Yes. So asylum, usually right now it's taking it could take anywhere from a year to get asylum to up to 5 years. Many people are waiting a long time. And then after that, you've been granted asylum if you can show you've been here for a year, over a year continuously. Apply for the green card, and then from the green card you have it for 5 years, you can get your citizenship. So that's where it's a path to citizenship. What happened to my child after VAWA was approved? The child is out of the country. So once you get approved and you're probably going to apply for your green card, your child would be able to come as a derivative once you're approved for that green card. Good morning. I came to the United States with a tourist visa. I got married to a citizen after staying 2 months. My visa is now expired. What to do next? Your spouse and you should be looking at filing adjustment of status. Give us a call. We can evaluate your options just to see what's going on, because my next question is your spouse on board with you to file for that adjustment of status? So that's what you need to do pronto. Now, even though you've overstayed, since you're the spouse of a US citizen, you are still good to pursue adjustment of status as long as there are no other factors that are going to disqualify you. For example, if you came in with a crewman's visa. So if the family petition is filed and I'm over 21, can I file for adjustment of status at the same time? Not exactly. It gets more complicated. Remember that if you're 21 or over and you just filed your petition, unlikely you'll qualify for adjustment of status. As a matter of fact, you're going to have to go through a tougher process. And this is going to involve going through a possible waiver. Just depends on who is sponsoring you. Do you have a permanent resident or citizen parent who you can use to show extreme hardship? So as you can see, I can do a whole live on that process, but filing the petition alone isn't going to cut it. You're looking at 5 to 7 years if you're unmarried, and then you have to wait for your immigrant visa number to become current first before you can apply, which that's what takes 5 to 7 years. How long does it take for the work permit to be processed? Could be anywhere from a few months to a year. It just depends on what is getting you to the work permit, what qualifies you for the work permit. If someone does caregiving job and the owner treats you bad and even ted you in the night, what relief if you apply for she stayed on a B1, B2? Give us a call. In that case, the T status may be an option here, but I need to understand what is happening here. Usually in these kind of caregiving jobs, a lot of my clients end up getting approved T status because it's very common to go through labor trafficking in those industries. All right, I have to head out. Thanks so much, everyone, for your time. I will be back tomorrow and I'll answer some more questions. So hold on to your questions for tomorrow. I'll answer this last question. Can you represent your clients at interviews? Yes. However, if you're not my client from the beginning, I don't do those interviews because it wasn't my case to start with. I go all the way with my clients to the interviews when I represent them from the beginning, and my clients always have that option for me to attend. And I do travel all over the US to attend those interviews. All right, I wish I could get to the rest of your questions, but I will be back tomorrow. Just know though that we do have some good news here. And the way you're going to know whether you qualify for a work permit is to make that investment in yourself and schedule an appointment. And I ask very specific questions to see if you can obtain the work permit. That's the only way that we're going to know here, especially if you've already overstayed and you're trying to evaluate what your options are. All right, if you want to get in touch, go to the link in the profile, go to the link in the description of the video on YouTube, Facebook, and Twitch. You will have everything you need to schedule your appointment. There's a button to schedule your own appointment. You don't even have to call. There's a button to go to the website, learn more about me, learn about the law firm and what we do for our clients. And then you can also request an evaluation there as well. All right. Thanks, everyone. Have a great day. And thanks so much, Marianne. You too. Or Marie. Thanks, Marie. Bye-bye.